Good day. My name is Keshav Kent, and today I will be briefing you on the claim and the insurance question concerning standard ocean carriage. In relation to the dispute facts, Large Venue Video, which is the shipper, is claiming against Standard Ocean Carriage, the carrier, for the purchase price of the screens and related damages. The shipper claims that stowing the cargo above deck was quasi-deviation. The cargo was covered by Skald, who have indicated they may not cover the claim because the claim is for deviation. Additionally, the bill of lading notes that the cargo must be shipped below deck. However, there is no declaration of value in the bill of lading. In the case of whether there is deviation, the Carriage of Goods by Sea Act 46 USC stipulates that any deviation in saving or attempting to save life or property at sea, or any reasonable deviation, shall not be deemed to be an infringement or breach of this act or of the contract of carriage, and the carrier shall not be liable for any loss or damages resulting thereof. Additionally, from the cases Sedco Inc. v. SS Straithwaite and American Home Assurance Co. v. Tabuk, the concept of deviation is as follows. The doctrine of deviation applies only to the carrier's voluntary actions in unjustifiably deviating, when the deviation has so changed the essence of the agreement as to affect its abrogation. As previously stipulated, in the Sedco Inc. case, the doctrine of deviation only applies to carrier voluntary action in unjustifiably deviating way if it changes the essence of the agreement. However, in this case, it is also mentioned that mere negligence, lack of due diligence, or a failure to properly handle, stow, care, or deliver cargo has never constituted deviation. This is further elaborated within the American Home Assurance case, where they cited the Sedco Inc. case and agreed that the fact situation did not constitute deviation. After applying the facts from the two previous cases discussed, it appears that in the case of Standard Ocean Carriage, the carrier did not deviate by storing the cargo on the bow of the ship. Additionally, the Carriage of Goods by Sea Act, subsection 5, states that neither the carrier nor the ship shall in any event be or become liable for any loss or damage to or in connection with the transportation of goods in an amount exceeding $500 per package lawful money of the United States, or in case of goods not shipped in packages per customary freight unit, or the equivalent of that sum in the currency, unless the nature of the value of such good has been declared by the shipper before the shipment and inserted in the bill of lading. This declaration, if embodied in the bill of lading, shall be prima facie evidence, but shall not be conclusive on the carrier. This implies that the maximum penalty, according to the Carriage of Goods by Sea Act, is $500 per package due to the fact that the value was not declared within the bill of lading in the specific case at hand. Concerning the insurance policy, and specifically the grant, according to Article 5.2.5 of the Skald insurance coverage concerning cargo liability, the standard insurance shall not cover liabilities, costs, and expenses if the cargo is carried on deck, unless the cargo is suitable for carriage on deck of the entered vessel, and the contract of the carriage contains an appropriate liberty to carry cargo on deck, and the contract of carriage is specially claused to the effect that the cargo is carried on deck and that either the carrier is exempt from all liability for loss or damage to such cargo. In this case scenario, the standard insurance shall not cover said liabilities based on the lack of these three requirements. As for the insurance policy concerning the trigger, according to Article 6 of the Skald insurance coverage concerning extra cargo holding costs, the standard insurance shall cover the member's extra costs and the liability for extra costs in connection with or as a consequence of handling or disposing of cargo, where such costs are necessarily, reasonably, and solely incurred as a direct result of damages to cargo on board the entered vessel. However, there are exceptions, and the standard insurance shall not cover costs of liability which result from the vessel being overloaded or improperly stowed. In the case at hand, the vessel was considered to have been improperly stowed by placing the cargo at the bow of the vessel, and therefore this coverage cannot be applicable. Concerning the insurance policy, and specifically any possible limitations, according to Article 1.2 of the Scald Insurance Coverage concerning general limitations of liability, the cover afforded to a co-assured referred to in paragraph 1.1 shall extend only to risks, liability, and expense arising out of the operations and/or activities customarily carried on by or at the risk and responsibility of ship owners, and which are in the scope of covered afforded by the rules and any special terms set out in the certificate of entry. As for the resolution of dispute with Scald, according to Article 47.1 of the Scald Insurance Coverage, unless otherwise agreed, any dispute between the association and any member, co-assured, affiliate, former member, or any party making a claim on the association shall be determined by arbitration in Oslo. Furthermore, in Article 47.2, it stipulates that each party shall appoint one arbitrator who shall together appoint a chairman of the arbitration tribunal. Although if the two arbitrators fail to reach an agreement on the appointment of a chairman, the chairman shall be appointed by the Chief of Justice of the Oslo District Court. Finally, it is mentioned in Article 47.3 that the rules and any arbitration proceedings shall be governed by Norwegian law, except that the Insurance Contracts Act of 1989 shall not apply. I would like to thank you so much for your attention today. If you have any questions or concerns, please do not hesitate to contact me with the email or phone number below. Thank you.